you.
Okay, good morning, everyone. I hope you can hear me. Now we had a technical thing with my computer, but now it should work. And I think if we're all ready and if you can hear, we should get started. And I would welcome the two speakers, Samuel Baumgartner and in the IT. I'm very happy that you're here today. I know you've been very, very busy over the last week, so it was really hard to get you into today's talk. So I'm very grateful to both of you. And I think Bailun is now going to start the session.
So we start now?
Okay, oh, we are online. I thought we were going to have the nice music, but today we don't have any music. So I would like to welcome the audience then as well. And I would really like to introduce our two guest speakers, Samuel Baumgartner and Yachi Liu, both from Wenfei, as I said. They both have tremendous experience working in China. Yachi is working with leading actually two of the offices for Wenfei in China. And Samuel has just returned, I believe, from China. We had you in a meeting. So maybe you want to add some of you, you know, what your experience is and so on and so forth. I know that your law firm is the one who in Switzerland who went to China first and who did this double consulting in China on site. So you're very famous in terms of a Swiss law firm going into China with a long-term experience. Now, Yachi, I think you do it together with Samuel, and you will talk about legal and policy updates after the COVID-19 pandemic. We've seen a lot of things going on in China, a lot of development addressing the pandemic and the economic features in this relation, the economic influence. And I know that China has implemented many measures. So I'm really happy that you will address this today. So please, the floor is yours.
Thank you, Esther, for all the nice compliments. The pleasure is all really ours to be here today to share with us the legal and policy updates after COVID-19 pandemic. As you already mentioned, we are one of the very first law firms to have offices in China. So naturally, we experienced a lot of matters that relates to both from the Swiss side and the Chinese side, especially during these special times. We actually got more inquiries than before unexpectedly. We actually expected the business to die down a little bit because of this pandemic, but actually there are more stuff going on and companies are actually reacting quite quickly to digitalize their business to the best extent possible. And then naturally comes after that, then we have all the possible inquiries, dispute resolutions, and all those mandates coming in. So as said today, we are very happy here to give a presentation to everyone that regards to some of the many legal and policy updates today and hope that will relate to foreign investors in China. And let me start with today's topics. Our discussion today will be divided into two aspects. From the legal aspects, we're going to talk about the new guiding rules promulgated by the PRC Supreme Court regarding the treatment of civil and commercial disputes during the COVID-19 pandemic. And from policy aspects, we're going to talk about cost-saving policies and measures that are applicable to foreign invested entities in China during and after the COVID-19 pandemic. And that of course includes Swiss invested entities. Without due delay, let's go into the first subject. That would be the new guiding rules promulgated by the PRC Supreme Court. As you can see, the title is quite long. It's a very Chinese thing to have a long title document that confuses everyone. So usually we just shorten it. That's for avoidance of confusion, we just call it the guiding rules. What is it? It is a series of legal interpretations promulgated by the PRC Supreme Court. So that means it's a document of legal interpretation that applies nationwide, which means by legal force, it prevails over any regional legislation, regional court interpretations, and regional policies. It is only challenged if it is in conflict with any national laws. So as you can see, it has quite a high legal force here. And it was promulgated in 3 different parts, respectively in April, May, and June in 2020, specifically seek to address civil and commercial disputes created or affected by the COVID-19 pandemic. So if any case that has specifically elements that's related to COVID-19 pandemic, these rules will be specifically applicable in comparison to other more general rules, such as these cases include a wide range of kinds, including, let's say, contractual disputes, bankruptcy, lease, loans, or other kinds. And if in a contract that we're talking about, PRC law applies, the judge or the arbitrator involved in the case will have to consider these guiding rules when they make a decision. So these guiding rules, as we mentioned before, they come in 3 parts. Part 1 mainly covers the most frequently seen topics in these times, but in a very general sense. They cover force majeure, labor disputes, punitive damages, and those, etc. Part 2 covers their opinions on the adjudication of mainly 3 types of cases, which covers contractual disputes, such as sales contract, lease contract, construction contract, and training contract. And the second type is financial disputes that would involve, let's say, loan repayment disputes, credit card repayment disputes, mortgage disputes, even insurance claim disputes. And the third type is liquidation disputes, which are very often in these times associated with court enforcement procedures, which we'll talk about in detail in later. Part 3 covers various procedural issues, such as evidence collection, the extension of statute of limitations, or the rules of conflicts. It also touches upon some individual topics, such as letter of credit, bank guarantee, or maritime transportation disputes that are specifically related to international sales of goods, which are actually quite commonly seen during these times. As we know, many companies are actually engaged in or newly engaged in the sales of goods, medical supplies, medical equipment during these special times. And in today's presentation, we're going to talk about 4 major topics that are covered by the guiding rules. They are force majeure, sales contract, labor dispute, and bankruptcy. We're going to talk about these because according to our experiences during the past few months in this year, this seems to be topics that are most relevant to foreigners and foreign investors doing business in China. They have come up much more often than other topics. So let's go in with the first topic, force majeure. I think anyone that has to work with contracts on a daily basis would be so very familiar with this term. Under most jurisdictions that also includes China, force majeure means basically means events or factors that are unforeseeable, unavoidable, and insurmountable, which would give the party invoking force majeure the opportunity to be exempted from contractual liabilities. Usually in a contract, the specific scope of force majeure events are specifically specified just to avoid further possible discussions between the parties. They usually include government actions such as wars, natural disasters, fires, earthquakes, tornadoes, or social turmoil such as strikes or other kinds of social events that are not foreseeable. In our current situation, I'm sure if now the parties are entering into contracts, they will probably add one more thing. That would be the control measures adopted by local governments during this pandemic. In China, that usually means travel or operational restrictions enacted by the local government, quarantine measures that are there in case somebody travels, or confiscation of medical supplies or equipment by the local government. These could also be the force majeure events that should be considered by the parties when they enter into contracts. The regular process of a party invoking force majeure would be it happens, and then you notify the other party in writing, in a certified mail, in whatever form that you agree in the contract, and then you also substantiate how this event has affected your business or your performance of the contract, and then both parties will come to an agreement on either the termination of the contract or amendments to the contract. That would be the normal procedure. But under the guiding rules, we can see there are some differences and also highlights that we could see here. The first one is that the court will have a closer examination on the impact and the force majeure events, because China is a very big country, and ever since the beginning of the year when the pandemic struck, different areas would experience impacts on a different level. In the beginning, let's say during February, when most of the countries were shut down, some were still, when Wuhan was shut down, some were still open to a certain extent. And in April, when the rest of Hubei province was open, Wuhan remained shut down until later on in the beginning of April, and then it was reopened. So for these kind of differentiation of policy implementation in different areas, the courts will have power to actually examine on each case how the events occur, to what level they actually impact the local business. This is all very common because court need to examine the underlying facts and the situation to determine the liability of the parties. But what's unusual here is that the courts are also asked to actively investigate the situation there, to actually, if the court upon the assessment thinks that the business affected by such events are not so devastated to an extent that simply can perform, then the court are furthermore encouraged to guide and to request the parties to come in some kind of solution or settlement instead of a direct termination. This means that the court will have a much more active role in trying and hearing cases. They do not simply sit back and examine the facts and hear the claims by the parties, but they actually can go in more actively to look into the facts, to disregard the claims of the parties and say, I think it would be better to terminate this case, or it would be better if we just amend our contracts in this case. Then which lead to the court will then have a closer examination on the choices of the parties to whether to terminate a contract or have amendments on the contract. Normally, under the guiding rules, it's very clear that a preference is given to performance over termination, which means as long as the purpose of the contract is not devastated completely, the court will prefer to actually guide the parties into a performance or amended performance instead of termination. And in that procedure, in that review process, the court, apart from examining the underlying facts, they will also examine the notification process by the invoking party very closely. The notification process is the process where the party being affected by the force majeure events notifies the other party to say, we have this thing happening here, we're affected and we want to be exempted from liability. This is a very important process, and why we'll be talking about this later. And on top of that, and also what I would regard as the most interesting points under these guiding rules for force majeure topic is that whether or not a party receives subsidy or tax examinations or other financial assistance may also become relevant for the court to determine whether they can successfully invoke force majeure. This means if a party goes to a court to say, we are affected by the force majeure events, we want to be exempted from contractual liability. And if the court goes in and say, you receive government subsidies, you receive tax exemptions, which means you are financially relieved. And we want to consider that. So it will not be so easy for you to claim force majeure because it was not so difficult for you to perform, financially difficult for you to perform the contracts. Now this is interesting because then it gives the court actually power to consider factors and elements that normally would be considered irrelevant in a specific case. So what happens under these guiding rules, we would expect. Personally, I think if the court are given more power to examine the case, then basically the court or the arbitral tribunal, they will have more incentive, then they will be more active in looking into the actual force majeure events and to assess their impact. They also given more discretion on their assessment of the force majeure event and to make a decision for the parties whether to continue to perform the contract or to just have a valid termination. These are not the traditional roles that would assumed by a Western court. And they, on top of that, they would also be more inclined to find reasons to continue performance instead of ruling for valid termination. This is already very clear under the guiding rules. They could only rule for a valid termination if they find that the purpose of the contract cannot be achieved anymore. And they are also given more power to consider external factors, as we just said, to determine whether a party can validly invoke force majeure. So in general, the courts will shift from its traditional very passive role to a more active role to act as an investigator, assessor, or even as a mediator to try to solve the disputes experienced by the parties during this period of time. While these all seem very strange to Western eyes, these are actually not so new of a role to be assumed by PRC courts. In the very recent court procedure we have in Shanghai with regard to a lease disputes, where the court, normally they should be there to hear the claims by the parties and to decide whether those claims by the parties are either supported or rejected. But in this case, the court actually goes in and try to say to the plaintiff to say, your claims are too over the board, too overwhelming. Maybe you should consider reduce your claims to a certain extent. This would never have happened with the Western court because the court cannot simply go in and actively say, the claimant, you should change your claim of relief here. But that has happened often with Chinese court. And with the introduction of the guiding rules, we would expect it to happen actually more often, because then we see that the court are given more power to do this kind of thing. So based on these observations, we think that in dispute resolutions during this period of time, it's very important to avoid state courts, because these guiding rules, they are promulgated to specifically, to specifically guide the practice and behavior of the local courts. So state courts, in comparison to arbitral tribunals, will have a stronger inclination to actually adapt these rules. And for that, state court will find more reasons to rule in a surprising way that we would actually expect. So for that, we would recommend to, instead of state court, we would recommend to use arbitration institutions with professional reputations. For China, our experience would indicate that CTAC would, amongst all, would have to be the more reliable choice. The international ones, of course, they should be all professional, ICC, SHIAC, or even Hong Kong Arbitration Center. But for cases with smaller amounts in dispute, where you have to choose a local one, we would recommend CTEC over the other domestic arbitration institutions. And for invoking force majeure here, it's very important for the invoking party to notify the other party in a way that is in accordance with the contract. Normally, the parties will have agreed in the contract in what way they should notify the other party, by written statements or by certified mail, or even it has to be substantiated with an official certificate issued by the relevant authorities. That could all be possible. The parties invoking that should make sure that notification is conducted strictly in the way that the parties agree in the contract. It should also inform the other party very clearly how such events affected its business, and then establish the plausible chain of evidence to actually say that the invoking party is affected by such events. In this pandemic, sometimes those events are all covered in news, they're public, it's known to everybody. But in this case, a simple news or just a letter will not help you in court if you try to invoke force majeure. In a very recent case, arbitration case that we handled for a Swiss client against a Hong Kong company, the Hong Kong company tried to invoke force majeure to be exempted from contractual liabilities. And their claim is solely based on a written letter issued by the Hong Kong company to the Swiss company, saying there are now travel restrictions in China and we cannot perform the contract. But it was not issued, the letter was not issued in a way in conformance with the contract. In the contract, it says the letter has to be sent by certified mail, and it also has to be followed within 15 days by the specific proof on how the company was affected by such force majeure measures. So with simply a letter, even though in written form, even though it was clearly dispatched from the invoking party to the other party, the invocation of force majeure was not recognized by the arbitral tribunal. And therefore, the Hong Kong company has to bear the contractual liabilities for their breach. And well, that sums up for our comments on force majeure, on the topic of force majeure. And the second topic is about sales contract under the guiding rules. So we note a few highlights of the rules under the guiding rules that are different from our normal perspective. One is that additional cost resulted from control measures may be borne by the affected party, which seems quite counterintuitive. But as mentioned before, courts will tend to rule for performance of contract over termination as long as the purpose of the contract is not completely disrupted. So then they would try to still guide and persuade the parties into performance. Sometimes after a certain while, especially in times like this where the market changes and then the cost could go up and down in instant without any foreseeability, sometimes the performance could result in additional cost for the performing party. And here under the guiding rules, performance should still continue if the court rules for performance, even though if it results in additional cost for the performing party. And this could be quite disadvantageous for the performing party. Only if the court recognizes that it is very, very unfair for the performance to continue, then the court can, under its own discretion, either adjust the prices or to adjust the performance deadlines for the parties. Which means that even though under the circumstances where it might be completely unfair for one party to perform, termination might still not be possible. And the court is given more power to negotiate with the parties and to, under its own discretion, set for a different price or the performance deadlines, which I would consider to be a pretty generous scope of power to be given by a state court. And on top of that, if one party breaches and then it resulted in the loss of profit of another party, such loss of profit may not be always be supported. If the affected party, if the party affected by control measures cannot perform, and then it resulted in loss of profit by the other party, then normally such loss of profit will not be supported by the court. The loss of profit will only be supported in a very limited scenario where the affected party actually sold the medical supply goods in for higher prices in breach of the sales contract. And then that is the only scenario under the guiding rules that loss of profits suffered by the other party would be supported. Under general circumstances, this would be a very limited scenario to support loss of profit, because under normal circumstances, if one party breaches the contract, they have to bear the liabilities which would normally include loss of profit. And let's move on to the next topic, that would be the labor dispute. The labor dispute rules, we do not have many rules there, but two new rules are quite interesting. One is that if an employer wants to get out of the employment contract, because the employee is a COVID-19 patient or COVID-19 suspect patient, or a patient with a symptomatic patient, or a person that stays in quarantine, those kind of claim cannot be supported. Means that the employer simply cannot terminate because the employee is a patient or is in quarantine or simply comes from a very severely affected area. Well, this rule seems to be purported to protect the interest of the employee. In practice, it actually hurts both the employer and the employee. Why? Because if the employer cannot terminate with those employees, their clients, we often experience when clients of the employer will request the employer to undertake that they will not hire anyone that's a patient or that is suspected patient, or that comes from a severely affected area such as Hubei province. This has happened very often in the beginning of the year, where we have companies coming in saying we have signed a contract with a major company in China where we will act as their suppliers, but they will only engage us as a supplier if we promise them that we will not have any patients. If we have any patients as our employees, they will be entitled to terminate the supply contract with us. And because the suppliers often have a very limited bargaining power towards big companies in China, they often would have to accept this kind of usually very unreasonable terms. In the end, the employer suffers because it has to undertake the additional cost in labor, and then the employee also suffers because they cannot really receive adequate income during this period of time. The second rule is that the People's Court shall shall correctly understand and apply the policies and regulations developed by the local or state government. This again means that the court are given more power. Not only can they apply the guiding rules promulgated by the state, the PRC Supreme Court, but they can also rely on other policy documents issued by the local government in making of their decisions, which means then the court will have a much more discretion in in their interpretation of the policy and of the rule, and in how they make decisions in each specific case in this very chaotic period of time. And in bankruptcy cases, as we can see, again, the court will have more power because the court will be asked to examine, for a company going into bankruptcy, the court will be asked to examine whether these companies are actually really have lost its capability long before the hit of the pandemic, or it is only affected by the pandemic and then could still have a chance to recover after the pandemic. And if the court, after all its investigation, have come to the conclusion that there is some value left in the company, they are given the power to, again, given the power to guide and encourage the parties, which means the company going into liquidation and its creditors to go in some kind of settlement, to actually postpone the liquidation, or to even have other measures to suspend the liquidation or even reverse the liquidation if the liquidation is connected with some kind of enforcement. One example would be, let's say, the company is in debt and is hit by the pandemic. It cannot cover its own debts, and therefore the creditors asked for liquidation of the company. And the assets of the company have to be liquidated, sold, and then the remainders have to be paid out to reimburse the creditors. And during such procedure, such enforcement procedure, even if it's ongoing, even if it's already going into a auction process where the assets of the company are being sold publicly, if the court finds that there is still some value in the company, that they could still be a chance that they could still be saved after the pandemic, the court actually has the power to order a suspension of the enforcement procedure, and then to actually have the liquidation and enforcement procedure suspended for at most 6 months. And then during that time, the court can guide the parties to enter into settlement contracts, under which it is possible for the company to actually reverse the bankruptcy procedure, to actually get the auction suspended, to get the assets kept for the time being, and then maybe to get more funding in the time being, and then maybe in the future to repay with the funding and then to go back into operation instead of going liquidated. This would be possible also because under the guiding rules, the court is very expressly given this policy preference that continuous operation is preferred over a liquidation procedure. So as we can see from all 4 aspects, the 4 major topics under the guiding rules, it's very clear that the courts are given given more power to actually examine the facts, to actually go into the details, to interpret how the situation is, to act as the investigator, to mitigate and negotiate between with the parties, rather than to assume its traditional role to sit back and listen to the parties' claims and to only support or reject. Whether this kind of more active or aggressive role will be used to actually better solve conflicts or disputes between parties, or it will be used for the worse to accommodate some hidden agendas, is still left to be seen. As we can see, these are coming out only in April, in the middle of the year. So we'll see until the end of the year on how the state courts will use these kind of tools to resolve the disputes between the parties. And with that, I will invite my colleague Samuel Baumgartner to have some of his observations on the very, well, let's say Chinese style kind of legal interpretations that are promulgated during this period of time.
Yeah, thank you very much, Yachi, for this interesting overview. I'd like to wrap it up a little bit. It is always interesting to hear and study the Chinese practice with you, especially because, as you said, the approach is so very different from what we are used to from a Swiss perspective.
That's true.
Yeah?
That's true. You remember in our practice, it's very, very often very difficult to explain to a Swiss client or a Swiss lawyer on the practice of Chinese courts. They often find it very intruding or very, let's say, parental style kind of practice there.
Absolutely, and this is an example of why that is, because in Switzerland, the abstract norms are given by the legislature, so that would be the Federal Assembly, and in some cases the Federal Council, and the courts are then only supposed to apply the law to the individual case that it is presented with. Of course, they would normally be expected to do that in a similar way in every case, but you wouldn't know how a court is going to decide until you actually give it the case to decide. In any case, the court would not issue guidelines on what it is going to do. The practice of issuing guidelines, as you have indicated, Yachi, of course, raises also questions. A guideline can never be precise enough to take into account every specific detail that every case has. So under which circumstances would the lower court judge that has to apply the guideline be willing to disagree with the guideline or deviate from it because he finds that the case he's looking at has a very specific detail that does not fit into the solution provided by the guideline? Would he do that and deviate from it, or would he just apply the guideline? Well, likely the latter would be true, as we know. But then again, in the practice that we have, it's often then difficult to explain that you can sometimes not explain why a specific detail will be heard or will not be heard. And if you are in that situation, where does one go if one feels the guideline isn't right, is not doing justice to the specific case? So while the approach, as we are used from China with the guidelines, is certainly a very practical one and probably a very efficient one, it may, on the other hand, not do justice to each and every individual case.
That is actually quite true, because as we were talking, apart from these very universally applied guidelines, we often also see those letters communicating between the higher courts and the lower courts. Sometimes they publish that, where the lower courts will write an inquiry to the higher court saying, we have this case and the specific circumstances are like this, and we would like your guide in how we would rule in this case, which would be very hard to understand in the Western world, I suppose. How can a judge ask for the help of a judge for a superior court to tell him how to judge a case that he is hearing? Yeah, but
absolutely. Maybe just a short wrap up also on something that I checked from the Swiss side. The Swiss Federal Court obviously doesn't not issue guidelines, and I also mentioned this because we are on a Zoom meeting. It doesn't issue guidelines, but it of course already dealt with the consequences of the pandemic on a more procedural level. In a very recent decision, it struck down a decision that was handed down by the Zurich Commercial Court. The Zurich Court insisted on holding a Zoom hearing, and that was against the explicit wish of one of the parties. And the federal court struck down this decision from the commercial court, stressing that each party has the right to be heard in person. Meanwhile, this has also been confirmed in an ordinance that was issued by the Federal Council. I thought that was interesting in time of Zoom meetings. While they are great, it's still a nice reminder that most important messages are still delivered in person. All right, Yachi.
All right, on that interesting ending note, I think we should now move on to the policy side. Well, we'll start with the policy, important policies that are applicable nationwide for cost-saving measures. Those measures come usually in two main aspects.
Excuse me?
Yes.
Maybe this would be a good time to take questions, because you have so many interesting topics that you addressed today. But I think if we move on now, we may lose some of the questions. I don't know whether there are questions in the audience. I can't see any.
No problem, no problem. We will be open to take questions anytime. Because actually,
I personally would be keen to ask you a question, because you gave us so much detailed information about the court proceedings and the practice, which is really helpful once we have cases. But what I'm not so sure now, because we're all lawyers or we have some companies in here, but if we look to the future, we would like to know, how do we get about that in future contracts? And from what I learned today, I would presume you recommend we do arbitration. We go, if it's local arbitration, we go to CTAC. If it's not foreign arbitration, regarding CTAC, my question would be, if it is not under a foreign law clause, but if we have actually Chinese law applicable to the contract, would CTAC not also have to rely on these guiding rules that you explained?
Yes, we would have to rely on these guiding rules. But as you see, these are the same set of rules, but it might be different under different interpretation by different people.
Yeah.
We want to avoid to have a very active judge coming in to say, I know what you should do, you know, you should do this, you should do that, which we would normally, which would not very welcome by Western clients, which is why most of our clients would prefer their judge or arbitrator to remain a rather passive role there, which is why we tend to, even though the rules are there, we would expect someone that's more passive there to be interpreting them, which is why we would prefer arbitration institutions over state courts.
Yeah.
Actually,
if I may follow up here with the state court in China, could it in fact be that the Chinese court would apply a foreign law if you have a foreign law clause in the contract, and this would be, you know,
of course,
they would. But they would not overrule it with this new guiding provision. They would not say this guiding provision overrules the foreign law in this aspect, and we still need to go into the case and look into the details.
If it was very explicitly agreed upon in the contract to say foreign law applies, then I couldn't see any reason why the local court would say, no, we are going to apply Chinese law instead, because there's simply no legal basis for that.
Yeah, that is true. And that I was just wondering, maybe that this guideline or guiding rules, or however you call it, you know, that they could say this is sort of mandatory Chinese law that prevails in any case.
It's from a legal perspective, they are part of Chinese law, but I would not expect them to apply these rules in the legal force that's higher than Chinese law. Let's say there is a dispute here, and then Chinese law applies. Then of course these rules will apply. But then if the parties say, no, we have agreed upon this, Swiss law applies. One party is Swiss, one party is Chinese, and then we have agreed that Swiss law applies. Then it is very, I would be quite surprised if the court could say, no, Chinese law applies, these guiding rules will apply.
There is just a question that I saw here coming in from Andre Brunschweiler on this exact topic. He asks, can one exclude the application of these guiding rules by way of choice of law in a contract or dispute resolution clause? Or are these guiding rules mandatory law?
Exactly my question.
Okay. Of course, you can exclude the application of these rules. You can exclude the application of PRC laws. Actually, for most of our cases, where often one party is Swiss and one party is China, we would recommend to you can apply Chinese law, but then you have to have a foreign institution, or you can have or you can apply foreign law. It's never Chinese law plus Chinese institution. That's no good. But to answer your question, yes, if one party is a foreign party and the other party is Chinese, you can always contractually agree to exclude the application of Chinese law, which of course include these guiding rules.
Okay, so this gives us some help, I think, in planning and in looking forward. I also understand we should have detailed rules and apply to the rules regarding notification of force majeure events. I thought that was also very interesting.
Actually, in practice, it also depends on how you draft the contracts. If you draft the contracts very clearly and you have a very clear mechanism on who should do what at what time and what consequences there will be if one does not do that, it also then gives the court less room for interpretation. Often we would suggest that you agree everything in advance very clearly so that you do not find yourself in a very uncomfortable situation where you listen to a judge to say how he interprets the contract. That's the strategy here.
Thank you very much. No more questions from my side. Maybe the audience has some questions on that first part. No more, so please, would you like to go on, please, then? And sorry for the interruption.
No problem. Actually, the discussion makes it more interesting, I think. Otherwise, I think if one keeps on talking about these kind of topics for too long, the audience might fall asleep sometimes.
Yeah, and now we have we had these COVID things and we have the rule and we need to look forward as well. So I think it's useful, to look into how you address that in future contracts, and that should be helpful to the audience. Okay, but now please go on.
Yes. Okay, let's go on to the policy aspect. Nationwide, as I just mentioned, these cost-saving policies and measures, they usually come in two aspects. One is, let's say, preferential treatment that we have for companies in their social insurance contributions. And the other is, of course, tax exemptions. And nationwide, we can see that most of these policies focus on giving help to small and medium-sized enterprises and to enterprise in specific industries, such as those that are manufacturing or transporting important medical supplies, or enterprises that are severely affected by the COVID-19 pandemic, such as hotel, dining, tourism, transportation, those kind of industry. The first can see small to medium enterprises that do not lay off workers or lay off few workers can ask for return of the unemployment insurance premium they paid in the previous year. This has been proven to be feasible, and I know for sure that some of our clients in Shanghai have already gotten their unemployment insurance premium back that are paid last year. Here I would like to stress that lay off few workers, probably some companies do not exactly know what does that mean, how far does that go. According to practice, we can see if a company that lays off less than 20% of its workers, they may have a chance to apply for this return of insurance premium. The second is that small, medium-sized, and micro enterprises can be exempted from contributions of three kinds of social security premiums that include old age, unemployment, and work injury. Just from a practical side, and then notes, these three kind of social security pays to the employees. So if the company can be exempted from these payments, then at least 16 to 17% of the cost they spend on HR can be saved. But these exemption only last for 5 months at tops, and also only for small, medium, and micro enterprises. For larger companies, this exemption is only valid for 3 months, and it's not a full exemption, but a 50% reduction, which means around 8% for the period of 3 months. The third is 50% reduction of employers' medical insurance contribution for their employee. This reduction applies to all employers, means all companies, large, medium, small sized companies, they can all apply for a 50% reduction they pay for this medical insurance of their employees. And that translates into about 5% of their HR cost. And for tax exemptions here, we can see there are VAT exemption for transporters of key materials for the pandemic prevention and control. That means if you're transporting important medical supplies and equipment, then the value-added tax can be exempted, which for transporting companies would be 11%. And there is VAT reduction for small-scale taxpayers for companies that are located inside Hubei province. These, they normally would be subject to 3% VAT, but now it's reduced to 0%, meaning they are fully exempted from VAT until the end of 2020. For other small companies located outside of Hubei province, but in China, they will be subject to a reduced VAT of only 1%. Their normal rate would be 3%, but they will enjoy the 1% preferential rate until the end of 2020. And also for companies that makes very little income, which means a monthly income lower than 100,000 RMB or a quarterly income lower than 300,000 RMB, they can defer their tax filing, corporate income tax filing for 2020. Meaning for 2020, they do not have to declare any income or pay any corporate income tax. They can wait until the end of 2021 and then file it all together. And for industries that are severely affected by the pandemic, just as I said before, transportation, dining, hotels, and tourism, their losses, if they suffered any losses in this year, their losses can be carried forward and not compensated for a maximum of 8 years instead of the traditional 5 years. These measures are all there to help the company to get more liquidity and get more funding to revive. And for film screen service providers, this would mean for cinemas, they will also be VAT free, meaning they don't have to pay any VAT until the end of 2020. And for secondhand car dealers, this is actually quite interesting. Normally they have a VAT for 3%. This was already reduced at the beginning of the year to 2%. And then since May 2020, since May this year, this reduced rate of 2% was further reduced to 0.5%. And this preferential policy will be in force from May 2020 until the end of 2023. So this would be a major tax preferential policy for all second car hand dealers in China. And apart from these national policies, we could also see some highlights that are applicable in Beijing and Shanghai. In Beijing, for small and medium-sized enterprises and other companies who rent, or individuals, as long as they rent state-owned property, they can enjoy a 2 months rent-free period in 2020. Meaning, if you're a company in China, or if you're a person doing business in China and you rent your office from a state-owned entity, they should give you 2 rent-free period. They should give you 2 months of rent-free period this year. And for micro and small-sized high-tech enterprises located in a specific national innovation demonstration zone in Zhongguancun in Beijing, they may apply for a subsidy for their research and development. the maximum of that subsidy can go up to 200,000 RMB. And also small cultural enterprises can also apply for rent subsidy. And key enterprises that engage in the business of epidemic prevention and control can also apply for long interest subsidy. But what's important here is that the measures 2, 3, and 4, subsidy for high-tech enterprises, rent subsidy for cultural enterprises, and also long interest subsidies, there are policies out there, but they have to be applied for by the companies, and they can only be decided by a case-by-case basis upon the review of local government. How they're actually implemented and to what extent the subsidies are given out, it still remains uncertain for the time being. And for Shanghai, the same. As we can see, if you rent from state-owned property, then you get a 2 months rent-free period. They should, for at least 2 months in 2020, they should not charge you any rent. And then Shanghai government also gives local company various extensions for filing their tax declaration, VAT declaration, corporate income declaration, for paying their social insurance contribution and housing fund. This does not mean that these are exempted. It just means that the companies can wait for a few months when they have more sufficient fundings and then pay. This measure is there to try to give companies more liquidity during these difficult times. And then the Shanghai government also gives subsidy to online training expenses. This means if a company, you offer online training to employees, you may apply to the government to have the cost of these online training subsidized to the maximum extent of 95%. This also, according to our experience with some of our clients in Shanghai, has proven to be feasible. They go online, they go to the online platform of the government, they file the application, they provide the documents requested by the government, indicating their expenses for the online training, and then they get the subsidy back from the government. The last is the preferential interest rate lower than the long prime rate. These are let's say, also another guiding opinion by the local government to some of the local banks in Shanghai to say that you should try to offer lower interest rate to small scale companies, small and medium sized companies in Shanghai, to companies that are in key epidemic prevention and control industries. And the interest rate should be at least 25% lower than the long prime rate publicized by the National Interbank Lending Center. While this is already promulgated by the Shanghai government, it's also is not mandatory, because in the legislation, in the policy, the government only says we encourage that banks do that, local banks do that. Whether the banks are actually cooperative remains to be unknown. According to our experience, we have a company that actually applied for loan with Shanghai Bank this year, but they did not get any preferential rates. They actually used, they already used the long prime rate, but they did not use any rate that's already lower than the long prime rate as encouraged by the local government. So how that policy can actually be enforced locally also remains to be seen. So I think that sums up to the end of our presentation today. Thank you all very much for your time and attention during this time. And if you have any questions, feel free to contact us anytime.
Thank you very much, Yachi and Samuel. Are there no more questions from the audience? We didn't have any written questions filed in. So, okay. So thank you again all for being here. And again to Yachi and Samuel for doing this very interesting talk and for giving us this information. I know that two of you are very busy, and I wish you a continuing successful business. And I know there's a lot of requests from Swiss companies now particularly, so it's good to know you're both in China and you can assist all these people. So thank you to the audience. We will continue our series on our legal webinars in September. You will receive an invitation again, so I hope that you will join us in future. As the situation of COVID has been sort of a normal now, new normal maybe, we may really continue on webinars as a very useful means of conversation, but I hope we will meet up in future on real life legal chapter events and meetings again. So thank you again for all of you for being here today, and have a good day. Thank you.
Thank you very much. It was a pleasure.
Thank you, everybody.